So a lot of breaking news tonight. The DOJ sending this letter moments ago saying in light of the threatened contempt citation against the Attorney General, the AG will ask the president to consider invoking executive privilege over the material that Democrats are demanding to see. So what happens next in this chess game? Luckily, we've got two experts with us, National Security Attorney Bradley Moss and former Deputy Assistant Attorney General John Yoo. Great to have both of you tonight.
Thank you, Shannon.
We were going to talk about this House committee contempt vote that is scheduled against the AG in the morning. The DOJ is saying, please hold off on it because now we're going to ask the president to consider executive privilege over these materials. What do you make of it, John?
Well, this is a rapid escalation in this constitutional conflict. Usually this kind of letter, the subpoenas, would take months, if not maybe a year, to get to this point. You're really seeing both sides already going to their most aggressive constitutional positions. Now, what's happened in the past, and I've worked on both sides, in the Congress side and the executive branch side on these issues. Usually what you do is you negotiate and come to some kind of accommodation where, for example, you would make the report available in a secret room where you couldn't take notes and so on. But it looks like both sides actually want to go to their extreme arguments and not reach any kind of compromise at all. Maybe you have to go to court, and this could go on for years.
Yeah, and maybe that's the idea. You never know what the calculation is, because today we know that there were meetings between DOJ staff for Chairman Nadler, and they were trying to work out some additional details about getting to see more of the report. Staffers, other people could look at the report. It would have a wider audience. But apparently that didn't happen. So now we're here. We're potentially invoking the executive privilege. Interesting to me that they include in this letter referring to a Democrat here. And they say, the committee has forced us to this, but they say President Clinton, acting on the advice of Attorney General Janet Reno, made such a protective assertion of privilege in similar circumstances. So, Bradley, you can see they're trying to say, hey, this is nonpartisan. It's an executive privilege issue.
Yeah, unfortunately, they're going to get, sideswiped a little bit by a ruling that came out there in the Obama administration in Fast and Furious when he tried to invoke executive privilege. If they tried to broadly and categorically invoke it here, as the Attorney General has, suggested in this letter, they're going to run into the ruling that came out in Fast and Furious where the district court stated that because of original previous official disclosures, the sum and substance had already come out. It undercut the department's argument, it undercut its ability to so broadly withhold information. I have no doubt that some of this could still be withheld under executive privilege. But if we do, as John mentioned, if this does end up in litigation, there's going to be a pullback on both sides a bit. There's going to be some more of this that comes out. And this is really just political posturing.
Well, and the thing is that we talked about this. We've talked about this multiple times. First of all, Chairman Nadler is smart. I mean, he is an attorney. He knows that there's a lot of this that could not be turned over by the Attorney General, even if he was 100% willing. He can't give out grand jury material. I mean, it's against the law. And secondly, they've offered Chairman Nadler and other Democrats and Republicans the chance to come see this less redacted version, and he hasn't taken them up on it. So, John, where do we go from here?
So I think you made some very good points in there. I think Chairman Nadler pulled the trigger too quickly on the subpoena. He can't subpoena the Justice Department to do something illegal. And that illegal act would be to hand over grand jury information. So actually, by acting precipitously, he has put Barr in actually a much superior constitutional position than he would normally be in. And so actually you could see the executive branch saying, great, Nadler's overreached. He's asking for too much. We know we will win in court on the grand jury information. We will probably win in court on the classified information. So fine, you want to take your best shot? We'll go right to court right now in these arguments. The way it's supposed to work is over a period of months, they should get closer and closer to reaching a deal. But because Nadler put out such an extreme position, you could see Barr and the Justice Department saying, fine, you want to fight on this turf? The second one, and just a little bit of difference with Bradley, the Supreme Court has never ruled on any of this. They have said there's an executive privilege. They've never ruled on this kind of law enforcement information privilege. They have ruled on grand jury in the executive branch's favor. So there's not much precedent out there. So if you're the executive branch, why not put the Congress to the test? I think that Congress has the tougher argument to make because they went too quickly.
Bradley, does it end up at the Supreme Court? Will I be covering it over there?
With President Trump, everything almost always ends up at the Supreme Court. That's where he likes to bring it in the end. So, yeah, I would assume so at this point.
I mean, I never thought that I would use my law degree and my years in legal practice as much as I do in the news. But we're glad that the true experts were here tonight. Thank you both.
Absolutely.
Thanks, Shannon.